Good morning, scholars. Good morning. LGL130, Intro to the Canadian Legal System students. Welcome to part 2 of our lecture on the Canadian Constitution. You'll have to forgive, I'm in the bedroom again on account of self-isolation and working from home. And, well, the light is very good in here to work as both a professor and a lawyer. It's a little dark on the camera, so I don't quite understand that. But anyway, we will get by. Thanks. I received some comments on yesterday's video, complimentary. That was great. I also watched it myself, and I see I need to get a better style, maybe, just to change around, maybe be a little more relaxed. But again, this is a work in progress. I'm doing my very best to provide you with as high a quality a lecture as I can given the circumstances. So I really do appreciate any constructive feedback you have. I have posted these videos on Blackboard as well as on the YouTube channel. So please feel free to view them in any way, shape, or form. Okay, sorry. There may be little stops in the video just because emails are coming in. Sometimes I get phone calls from clients, so I have to be very careful of that. So thanks for thank you for the patience. So anyway, today's March 24th, 2020, and it's actually a very big day both for our country and specifically for our class. Today is Parliament, the House of Commons in Ottawa has been recalled. And what's happening up there is that the Parliament is looking at emergency COVID-19 related measures that have been asked for by the Governor and Council, mainly, of course, the Prime Minister and the Cabinet. And so Parliament will resume today at, I believe, at 12 o'clock noon. So I'll be watching that on CPAC, the Cable Public Affairs channel, and just sort of thinking about, what happens. So today. But yesterday, and I will post this both on Blackboard and on the YouTube channel, the Globe and Mail released an article where they saw a draft bill which the Minister of Finance, Minister Marneau, is introducing to the House of Commons. And to put it mildly, it had sweeping powers. And so Twitter, legal Twitter, where I get much of my legal news these days, went crazy about it. They and they started talking about the Canadian Constitution. They started certain scholars, lawyers, and law professors started using case law, debating the finer points of taxation and leveling taxes by the House of Commons, and so forth. So it was really interesting to watch on Twitter last night. So at the end of the lecture today, I'm just going to do a very quick little introduction into what is going on in Ottawa today, and basically I have taken a couple of notes just to bring up. I will attach all relevant cases that I've come across. The finer points of Canadian constitutional taxes is not something I am an expert in by any stretch, but there was case law mentioned that was very helpful on Twitter, and I will post those for you, including the operative paragraphs, so you don't have to read the whole Supreme Court decisions because they're often quite long. So let's begin with a little constitutional law, and I think this lecture will be amongst the shortest. We're already at 4 minutes, but we'll just sort of quickly go through what is the Canadian Constitution, and then we will talk about what's happening on March 24th today. Okay, so if you want to turn your slides to number 11, slide number 11 of the slide deck posted on Blackboard, part 2, what is the Canadian Constitution, and let's quickly go through it. So we're going to talk a little bit about this when we talk about taxation later in this lecture, but what we do know is that the express wishes of the Fathers of Confederation, and that's what they were all male at the time, wanted to create a constitution that was similar in principle to that of the United Kingdom. Similar in principle. So it retained very, very obvious elements to it. A House of Commons, a Senate, which is the equivalent of the House of Lords over in the United Kingdom, and of course the monarchy. In the case of Canada in 1867, Queen Victoria, currently Queen Elizabeth II of Great Britain and Canada, Australia, and so on. So it had sort of the very cosmetic, obvious elements of a monarchy in juxtaposition, of course, to the republic down south in the United States, which was very much a republic, a republican form of government with a president and with a Senate and Congress and so forth. So yes, you look at the center block of the Canadian Parliament, which is being renovated extensively over the next 10 years. But it has a resemblance, much more so than the equivalent parliamentary buildings in Australia or New Zealand, for example. But the Ottawa, the center block, is very much Westminster in the wilderness, and that was one of its many nicknames. And so it had a constitution similar in principle to that of the United Kingdom, but it also had many ancillary items to go along with that. And these included conventions, constitutional conventions. So an obvious example of that, of course, is the Prime Minister. The Prime Minister is not named in the Constitution itself. There's sort of no designated section for the Prime Minister. But we have, by way of a convention, a leader in the House of Commons who forms the government, becomes sort of the Queen or the Governor General's chief counselor, chief advisor, and that is, of course, the Prime Minister of Canada. The very first Prime Minister of the United Kingdom happened, of course, and we've talked about this in class, when you had German Hanoverian monarchs in the United Kingdom who had trouble with English. And so Prime Minister Walpole, Horace or Robert, I can't remember. I'm going to check that. Hold on. I'm back, and through the miracle of modern technology, it was Robert Walpole. So the first, largely seen as the first Prime Minister of the United Kingdom, was Robert Walpole, the first Earl of Oxford, and Sir Robert Walpole. So he's regarded as the de facto first Prime Minister of the United Kingdom, and he lived from 1676 to 1745. Prime Minister of the Great Britain from 1721 to 1742. Okay, onward we go. So, we have conventions. We have practices very similar to conventions. Don't really want to dwell on those. We have sort of the House of Commons, which is governor, which is the body, the legislative and deliberative body, that makes laws, or and that will be in action later today in what will be I suspect will be a very interesting debate, because I think there's an all-party consensus that major actions need to be done with what's going on outside the window with the COVID-19 crisis, but at the same time, so they will try to strike a balance between getting stuff done for Canadians, but also making sure that their beliefs are recognized. Political parties and political debate in the House of Commons and in the Senate, very important characteristic of what we have in the form of the Constitution. The common law. We have the common law as it was received into Ontario, Upper Canadian, Canada West, Ontario, and Canadian English-speaking law from 1791, on account that this land where we are now was deemed by the British powers from before as settled land. Okay, and again, we've talked a lot about Aboriginal law in the context of this class. Maybe not a lot, but we have to address the issue, so don't really want to go there. But of course, it left the civil law in Quebec for private matters, as we talked about. So, okay, yeah, our unwritten constitution. So we have a written constitution, very obviously found in the Constitution Act of 1867 and the Constitution Act of 1982, which contains, of course, in its first 34 sections, the Charter of Rights and Freedoms. But let's look at sort of practices and conventions. What are they? Okay, so the selection of the Prime Minister. Who is the Prime Minister of Canada? Well, the Prime Minister of Canada is the woman or man, and to date we've only had one woman prime minister, but between you and me, and maybe anyone watching on YouTube, I think Chrystia Freeland is demonstrating that she would make a very good Canadian prime minister. But of course, we'll see what happens there. We have a selection of the prime minister. The prime minister is the leader of the party in the House of Commons, and to date there have only been two parties from two respective ideologies that have governed Canada. The first, of course, is the Liberal Party of Canada, currently in government, and we also have sort of the Conservative or the Progressive Conservatives, now the Conservatives at the federal level and the Progressive Conservatives at the provincial level, those sort of variations of that party, because that party has evolved and changed over time. But the leader of those parties typically will make up become the prime minister, because they will win the election and command the House of Commons. They will have the most seats, their party will have the most seats, and they will be able to command the House of Commons in confidence motions. So that's sort of how we have our prime minister. Prime minister is, of course, the chief advisor to the the governor general, and that is called the governor in council. So when you see that as written in a legal fashion, and we will do that along the lines a little bit later in this lecture, you'll see that the governor in council is basically the governor general making decisions with her or his cabinet, governor in council, the chief amongst that, and the most powerful player in that group, of course, is the prime minister. So that is, that's the executive branch. The executive branch, the crown, the lieutenant governor, or the governor general, depending on what level of government, and the premier or the prime minister. So that's sort of a convention. We have political parties: Liberal, Conservative, NDP, Green. Again, that's what we have. We have the rule of law. Okay, nobody, especially the government, governing people is above the law, and that, of course, goes all the way back to Magna Carta in 1215 and so forth. We have an independence of the judiciary. We have a judiciary that runs itself. And currently, during the COVID-19 crisis, you've seen, notice to the professions. The judges are telling lawyers, and they're telling, lawyers and the law firms, is that this is how it is. This is how the courts are going to function over the next little while. So right now, everything but urgent matters and criminal and family and civil matters are being looked at. So most of the cases I have been working on, in fact, all of them, have been adjourned because there was nothing truly urgent there at this time. And parliamentary supremacy, and this would change over time, of course, because we're going to talk about the Canadian Constitution and how the Canadian Constitution is the most important and powerful law in the land. So we have parliamentary supremacy, but not when it comes in conflict with the Constitution. We'll talk a little bit about that. And then, case law and common law. And we know a lot about that. We're not going to belabor those points. So we've talked a lot about, Constitution Act Section 52, okay? Constitution Act of 1982, Section 52. And that provided the Canadian Constitution with an entrenched statute status, okay? So the Constitution Act, the Constitution of Canada includes the Canada Act 1982, including this act, the acts and orders referred to in the schedule, and any other amendment or any other act referred to. So basically, the Constitution Act has sort of a status. We have the Constitution Act 1867, Constitution Act of 1982, and sort of any other things that they reference. And a lot of those are a lot of the old British statutes, but have sort of been referenced in the schedule. Again, we don't really want to get into the weeds of that. This is a broad overview course. So what does the Constitution do? And I'm looking at slide 15 at this point. So what's the point of this whole thing, right? Well, as we talked about in yesterday's lecture, it sets out the framework for how this country should work. So what it does is that, it establishes a political and economic union based on democratic principles. So in the early days of prior to 1867, we know that Sir John A. Macdonald, who would become the first premier, the Kingston lawyer who would go on into politics and become very successful, Canada's first prime minister, He wanted a more unitary state. He didn't want provinces to be as powerful as they would eventually come. In fact, he didn't really want provinces at all. But there was an understanding by his colleague and friend, Georges Cartier, who in many ways acted and represented, French-speaking Canada. He knew that sort of the unique characteristics of French-speaking Canada, even up until, of course, from 1763 under British rule up until 1867, which constituted a population that was French-speaking, largely Roman Catholic, had a civil legal system based on the old Roman law, Justinian Code, Napoleonic Code, however that came along. But there was sort of unique characteristics, and Mr. Cartier wanted to preserve those in the form of a federal government. Of course, the federal government was not unique to Canada, because just south of the border in the United States, they had a very federal state. And one of the reasons that Sir John A. Macdonald didn't want that is because there was a fractious nature of the federal state that happened in the years prior at the U.S. Civil War. Because you'll remember, of course, in 1861, the southern states broke away from the northern states, declaring themselves the Confederate States of America. So all that was very much in the mind of Sir John A. Macdonald, but Georges Cartier knew that it was probably going to be a non-starter with Quebec if they didn't have some protection for the French nature of the province. So it establishes a political and economic union based on democratic principles. It established the framework of how government institutions are supposed to act. So, and that's very specific in the Constitution Act 1867, where it outlines in sections 91 and 92 what are the responsibilities of the levels of government. And so that is a very, very important element to the early days of the Constitution. Who does what? So what are the responsibilities of the federal parliament and eventually sort of the federal government? So the federal, what can the federal legislature or the parliament, what can it legislate, and then what will sort of the executive branch, the governor and council, the prime minister, etc., what responsibilities will they have? And what will the provincial legislatures do? What will get done by Queen's Park in Toronto or Quebec City? In the Quebec legislature, the National Assembly in Quebec, what will they do? And of course, in the middle, working its way through the system, the court system, and how the courts will handle matters. So it is it did confirm the ties to the United Kingdom as well through the crown, through the monarchy, the similarities of the governance itself with the prime minister, the Minister of Justice, the Attorney General, these things. So it was there as well. So let's move, slide number 16. So if we get to the Constitution today, it's three main documents, really, and with a lot of ancillary documents, with conventions, all sorts of things that go that way. And but basically, we're looking primarily for the purposes of this class at the Constitution Act 1867. And the biggest, most important element of that is sections 91 and 92. Who does what, federal or provincial? The Constitution Act 1982, which has, entrenches the Constitution. It discusses how to change the Constitution, which Canada is a very difficult Constitution to change. And of course, the most famous element of the Canadian Constitution more generally, the Charter of Rights and Freedoms, which is Section 1 to Section 34 of the Constitution, Act 1982, and increasingly Section 35, the element that reaffirms Aboriginal elements of the Constitution and treaties that have been made in the past. So very, very important elements to it there. And this is sort of an interesting element, and we talked a little bit about Pierre Trudeau, the Prime Minister of Canada in the 70s and in the early 80s. And I read to you from an article he wrote in Maclean's magazine in 1964 about how he wanted an entrenched Canada and the reason entrenched constitution for Canada and the reasons why he wanted that. And there's a very key difference to the Constitution of the United Kingdom and the Constitution of Canada currently, and this is where you see sort of an element of the American Constitution coming up to Canada. And that is, of course, is that the Constitution in this country, consisting of, for the most part, Constitution Act 1867 and Constitution 1982, is entrenched. And so we have talked about Section 52, and I've used this maybe a little bit, maybe it's a little too bellicose for these times, but Section 52, the B-52, it can destroy, any law that comes up against the Constitution it has no effect. That's a very important element to the Constitution that we have in Canada now, and that's manifested in the courts. If a criminal code section is deemed to be against a charter right or contrary to a charter right, it is ineffectual. That is the importance of the Canadian Constitution at this time. It is an entrenched statute. But because it is an entrenched statute, it's also given a little bit more flexibility in the language. And, the living tree idea. And Lord Sankey, in this case Edwards, and Canada back in the early 30s talked about this. The Constitution is intended to be a living tree and have a certain level of flexibility in its interpretation. Various cases, will, read things widely. Okay, give it a very, very, what's called a purposeful approach, and give it a wide reading. And there's various cases there, which we won't go into because we're at 21 minutes, and we're at the end of the lecture slides. So we will continue with part 3 tomorrow. But before that, I just wanted to prep you for what is happening today on March 24th, 2020 in Ottawa, almost as we speak, because it's almost noontime now. So let's go back, excuse me, to history again. And we'll talk, I've talked about this a lot, the Bill of Rights of 1689. Okay, so if you go back to England, we will remember there was a conflict between the king and the parliament, and there was sort of a jockeying for power. And in the settlement that happened after what's called the Glorious Revolution of 1688, where King James II was booted out of office, so the king and his daughter, who had married a Dutch prince named William, so his daughter was named Mary, and the Dutch prince was named William of Orange, and they were invited to assume as co-regents of the crown of England. And this was a step up for the Prince of Orange. This was to be invited to become the king of England at the time was a step up. Not to diminish, of course, the Netherlands, but it was something that King William and Queen Mary took up. And as part of that settlement to be named king, there was a Bill of Rights, and it became part of English law and eventually part of Canadian law as well. And amongst those in the Bill of Rights, one of the conditions of William and Mary becoming regents of England was that no taxes could be levied without Parliament's grant or the consent of the Parliament. So if, basically speaking, if William was going to go to war, you could go to war. It was a prerogative power, and we've talked a lot about prerogative powers in this class. But if you're going to pay for it, you're going to have to get our consent, the consent of the parliamentarians. And so that has very much survived into this, into the Canadian state as we know it now. Money bills have to originate from the House of Commons, and a big part of that, and we're missing that, and we're going to miss that, is around this time, in late March, the government of the day brings forth their budget and how they're going to pay for government, allocate government spending with the consent of the Canadian Parliament, of course, but what they're going to spend on for the next year. And so when I was, of course, working for the Minister of Finance back in the day, it was always a very big part of our work, the Canadian budget. So there you go. So we have this idea that money bills have to originate from the House of Commons, and this, of course, was found in the Constitution Act of 1867. So if we look at the Constitution Act, and again, it's going to be linked in the notes below on both the channel and on Blackboard. But if we look at Section 53 of the Constitution Act 1867, let me just find it here. Okay, it says quite clearly, under the title Money Votes, Royal Assent, Appropriation and Tax Bills, Section 53. Bills for appropriating any part of the public revenue or for imposing any tax or impost shall originate in the House of Commons. So a constitutional assertion via Section 53, that money bills must originate in the House of Commons. So I'm going to look at a little bit of case law just to sort of, what the courts have said about Section 53 of the Constitution Act 1867. The first case here is called Eurig, E-U-R-I-G, pardon my pronunciation if it's incorrect, estate. So it involved estate, I believe probate and that sort of thing. And it's from the Supreme Court 1998. And it will be posted for you to review on both of the mediums that I'm presenting this on. And so from that, I'm going to look at paragraph 30, and I invite you to do the same. In my view, and so just from the court itself, and again, I don't know exactly what judge is reading this, but in my view, the rationale underlying Section 53 is somewhat broader. The provision codifies the principle of no taxation without representation by requiring any bill that imposes a tax to originate with the legislature. My interpretation of Section 53 does not prohibit Parliament or the legislatures from vesting any control over the details and mechanism of the taxation in statutory delegates, such as the Lieutenant Governor in Council. Rather, it prohibits not only the Senate, but also any other body other than the directly elected legislature from imposing a tax on its own accord. So that's sort of, a judicial interpretation that basically the elected legislature has to be the originating point from any bill that's going to impose a tax. Moving forward a couple years to a case called Ontario English Catholic Teachers Association and Ontario, the Attorney General. This is from 2001 at the Supreme Court as well, and we're going to move down to paragraph 74. Okay, paragraph 74 here. And this sort of talks about the delegation of taxes, right? Because we know now that we have the state is a very big and active part in our lives, and I suspect that will be very much the case over the next little while. So this is sort of just discussing the delegation of taxing and sort of who's going to get the job done. So from paragraph 74. The delegation of the imposition of a tax is constitutional if express and unambiguous language is used in making the delegation. The animating principle is that only the legislature can impose a new tax ab initio. So only a legislature can start a new tax. But if the legislature expressly and clearly authorizes the imposition of a tax or a delegated body or individual, then the requirements of the principle of, quote, no taxation without representation, close quote, will be met. In such a situation, the delegated authority, so that being, of course, the lieutenant governor or the governor in council and the various sort of employees and people working in the executive branch, of course, head and led by the minister. In that situation, the delegated authority is not being used to impose a completely new tax, but only to impose a tax that has been approved by the legislature. The democratic principle is thereby preserved in two ways. First, the legislation expressly delegated the imposition of a tax must be approved by the legislature. Second, the government enacting the delegated legislation remains ultimately accountable to the electorate in the next general election. Okay, so why are we talking about these principles here? Is because if you'll read the Globe and Mail article, and I encourage you to do so, and it may have changed, but a draft bill that the Globe and Mail journalists saw yesterday said that this new bill, once it had been given royal assent, was going to give very broad taxing powers to the Minister of Finance. So Minister Morneau and his boss, Prime Minister Trudeau, were going to give basically powers to raise taxes through executive orders, through orders in council. And that was sort of very anathema to what we know and what we have had in our system with regard to taxes since 1689 and going a little bit further past that. So anyway, so that's sort of what's going on the docket today, or the notice and order paper up in Ottawa. But maybe I'll mention a little bit about it tomorrow in our next lecture. We're at half an hour, and I'm sorry this went on a little long, but there you go. So thank you for part 2. I wish you all the very best through your social isolation. Be well, and we will speak with you tomorrow. Take care.